Hello, once again from Fired Up. I'm your host for the show, Bob Irwin, broadcasting from Rigel Studios here in Las Vegas, Nevada. This show is about guns, related politics, and self-defense issues. Fired Up is on my website, firedupwithbobirwin.com, as well as the American Guns and Glory Network, YouTube, and numerous other media. If your local internet provider doesn't carry Fired Up, ask him to do just that. A new show is posted every Thursday around 5 p.m. Pacific time. And our audio feed is rebroadcast for radio listeners on Saturdays at noon on the Nevada Talk Network. You can check out KELY1230.com for a station in your area of Nevada. Last week's show got preempted by NASCAR. I guess I know I've made it when they preempt me for NASCAR. But that was a surprise. So we've covered a few more things in this show that we missed last week, just to keep you up to speed. If you have a question or comment, you can send me an email to bob@firedupmail.com. That's bob@firedupmail.com. Or leave a message on my office recorder. That is 702-257-1060. Again, that's 702-257-1060. If you don't leave contact information, I cannot call you back. There are several hundred defensive uses of firearms each week in the United States, rarely truthfully or fully covered by any mainstream media. I always select a few for each show for my listeners' education. Most are good shootings. Sometimes they're questionable. Some are just plain wrong, but all are educational for those of you that keep a defensive firearm in your home or carry one for self-defense in your vehicle or on the street. Individual incidents are generally adjudicated under local law. So the advice I give you here may not apply in the area where you live. Advice from a local gun-savvy defense attorney is always recommended. Stories are often paraphrased for clarity by me for translation from police jargon, lawyer speak, and regional accents into more standard American English. Incidents are as reported, but the names of the individuals involved are generally deleted. The identification of the cops, the lawyers, and the media, however, are generally used. So, with all that boilerplate stuff done, this first story comes to us from the Miami Herald on August 6, 2020, in Miami-Dade, Florida. A North Miami man will not be prosecuted for fatally shooting his former lover because he was under attack with brass knuckles designed to act as a powerful stun gun. According to the prosecutors, this is how the case unfolded. The victim here had fallen asleep in his car outside his North Miami home. Okay, he came home late, I guess. When he was awakened by a big bang, someone hitting his side mirror and door. He said it was his former lover, and the two began to argue about their breakup. She told the victim he could get the rest of his belongings at her home. Not long after, the victim drove over to the previous home, and another argument took place inside of that residence. Inside the home, the victim claimed his ex-lover hit him with a skateboard and continued to attack him. Ripped his shirt. He retreated outside where the fight continued. Surveillance video shows that the ex-lover was slapping the defendant in the face and the victim was not striking back, the police memo said. The ex-lover left and seconds later returned with the stun gun and brass knuckles, punching the victim in the face with the weapon. The video they have shows the victim fired moments later, unleashing a volley of bullets. The wounded ex-lover ran off and then died at a neighbor's apartment. The light from the knuckles is clearly visible on the video, the prosecutor said, indicating it could have been fired. The flash shows when the stun gun goes off. The stun gun knuckles are a niche security product marketed as ideal for joggers or runners who are suddenly attacked. The victim had actually bought the knuckles for his ex-lover at a gun show. Under Florida case law actually, the brass knuckles have been ruled as a deadly weapon. According to the prosecutors, the victim did not flee, but instead went to his car and called 911 to report the shooting. It turns out his firearm was legal. Also, he had a valid concealed firearms permit. The state declined to press charges against the victim for the shooting, as prosecutors said he only fired after he was hit with the knuckles, which are also capable of shooting an electric bolt similar to a stun gun. Under Florida's Stand Your Ground law, someone does not have a duty to retreat before using deadly force to counter a threat. Same thing we have here in Nevada. It also put the onus on the prosecutors to disprove the claim of self-defense. The state cannot prove that his actions were not justified. That's a quote from Assistant State Attorney Tiffany Finger. She wrote that in her memo. Thus, he is immune from criminal prosecution. Comments here are, this is a clear case of self-defense in a domestic fight. The Assistant State Attorney comments that the state cannot disprove self-defense is a bit worrisome. Our laws are supposed to be innocent until proven guilty, not the other way around. If Miami-Dade has actually decided to reverse the presumed innocent standard rather than just this particular prosecutor, the Florida state government needs to intervene. We are losing the presumed innocent, and while the state AG is saying that, well, we don't have enough evidence to indicate that he's guilty, therefore we're not going to file charges. He should be immediately then presumed not guilty. So hopefully that won't go any further in Florida. They're generally fairly pro-gun. A worrisome case. When you read the details, it's really tough. I will mention, although I didn't put it in the outline, for avoiding confusion, the victim here and his alleged attacker were born male. If that makes it more common sense to believe that she had enough physical strength to harm him by hitting him with brass knuckles. It's a new world we're in, guys. The Tulsa World reports August 7th, 2020 in Tulsa, Oklahoma. Tulsa police are searching for a man with a gunshot wound after a homeowner reportedly shot two men who broke into his home early Friday morning. Officers responded to the home in the 800 block of North Haven Avenue just after 1:30 in the morning Friday and found the homeowner bleeding from the head, apparently after being pistol whipped. The homeowner said his dog's barking alerted them to the intruder's presence. The intruders entered the home while the homeowner, his wife, and child were sleeping. Well, no kidding, it's 1:30 in the morning. The homeowner told investigators he managed to take the gun away from one of the perps and shoot both intruders with it. One intruder was found on the floor in a bedroom with a gunshot wound to the head. He was taken to St. John's Medical Center and was pronounced dead later Friday morning. The second intruder remains at large after fleeing the scene before officers arrived. Police say they have checked local hospitals unsuccessfully. Anyone with information is asked to contact Crime Stoppers by phone. They are reachable at 918-596-COPS, cops. That's 918-596-2677. The homeowner was reportedly hospitalized with his head injuries. Comments here, as most regular listeners know, I really love yappy dogs as a burglar alarm. Would-be burglars generally pick another target when the dogs start raising a ruckus. The fact that these intruders continued indicates they might have planned to leave no witnesses alive. It's a great deal easier to defend your residence if you have your own firearm. Depending on the intruders, to bring you a home defense firearm is a bit risky. I'm being humorous there. The 2-on-1 fight decreases the odds of your family's survival. All in all, considering what could have happened, it's a great outcome for the good guys. We're going to pause here for a word from some of our friends and associates. I'll be right back. This is a reminder to all our listeners. Keystone Corporation, it's a conservative organization that I'm on their board of directors, is having their annual dinner on Tuesday, October 6th, 2020. The featured speaker is Karl Rove. It is at the Venetian Hotel. For information, you can visit online to www.keystonenevada.com and get all the information. Tables are available for groups, and Karl Rove is an amazing commentator. You don't want to miss this. It is going to be the conservative event of the year. Freestyle Martial Arts, located at Jones and Russell here in Las Vegas. You can reach them at 702-551-9009. That's 702-551-9009. CCS Gunsmithing. Chris Eifelt, the man who does all the NRA help, he's at 2216 South Rainbow Boulevard near Sahara. He can be reached at 702-365-1732. Once again, 702-365-1732. Jerry Creed, a trust attorney. If you have a firearms trust or need one, this is your guy. You can reach Jerry at 702-806-7777. That is 702-806-7777. CCW Maggie is found all over the internet. You can reach her by phone at 702-375-5900. That's 702-375-5900. All sorts of firearms training, ladies only classes. She is the best of the best. Call CCW Maggie. Okay. We are back as promised. This next story comes from KOMP News Radio and the Kitsap Sun, reported August 5th, 2020 in Poulsbo, Colorado. I know I'm saying that wrong. It's Poulsbo. An incident started about 4:30 p.m. on Viking Way, where a 38-year-old was believed to have been driving a 2008 Jeep. Witnesses say he was traveling at a high rate of speed when he rear-ended a pickup truck. The 38-year-old perp then continued driving, but crossed into the oncoming lane and had a nearly head-on collision with another vehicle. There were no serious injuries reported from that second sort of crash, more like a near miss, it sounds like. The 38-year-old reportedly ran from that crash scene to a nearby property where he attempted to enter the house. You have the picture now. He jumps out and runs into a private home that's nearby. Deputies say a confrontation ensued between the 38-year-old and that homeowner that ended when the homeowner fired several shots from a handgun. The 38-year-old driver, now he became a home invader, was later declared dead at the scene. The homeowner was not arrested. He and his wife were cooperative with investigators and gave statements on Monday. Comments here are, sometimes trouble just finds you. If this second victim had cameras, an up-to-date alarm system, good door locks, etc., it didn't matter. Consider the damage possible if the homeowner was not armed and willing and able to defend his home. Keeping a firearm is clearly necessary in this time of high crime rates. Keeping the tools necessary to make your home safe is simply common sense. The left is always talking about common sense gun control. Common sense gun control is having a gun in your home or in your pocket so you can defend yourself when danger threatens. A lot of stuff available there. This next story, for radio listeners, as I mentioned at the top of the show, we got preempted last week by NASCAR. So my dissertation that was advertised on Garner versus Tennessee did not go out over the air in Nevada. If you subscribe to the show, it went out to the air anyway to your computer, but the radio listeners missed that. So the idea was to explain briefly the two Supreme Court cases that most affect law enforcement use of force. A federal law, the law is called 42 U.S.C. 1983. 1983 is the statute number, not the year of enactment, just for your clarification. It was enacted many years ago and has been modified several times since, here and there, as Supreme Court decisions have changed how it's enforced a little bit. Anyway, it requires that law enforcement officers of the United States, it requires that when law enforcement officers violate the Constitution during interactions with others, they can be criminally charged or sued civilly in federal court. The two major crimes that are referred most often over the decades have been decided based on the Garner case. A little information about what happened and why this Supreme Court decision reflects so often on current litigation and shooting incidents. To explain the case, I'm going to use a lot of paraphrasing in this story to shorten it. There have been several entire books written on Garner. It was argued at the Supreme Court October 30th, 1984, and decided on March 27th, 1985. There's a Tennessee statute that provides if, after a police officer has given notice of his intent to arrest a criminal suspect, if the suspect flees or forcibly resists, the officer may use all force necessary to effect the arrest. Acting under the authority of this statute, a Memphis officer shot and killed Garner after being told to halt as he fled over a fence at night in the backyard of a house he was suspected of burglarizing. The officer used deadly force despite being reasonably sure, he said, the suspect was unarmed and thinking that he was 17 or 18 years old and of slight build. His father subsequently sued in federal district court seeking damages under 42 U.S.C. 1983 for asserted violations of his son's constitutional right. The district court held that the statute and the officer's actions were constitutional. So then the appeals started, and ultimately the United States Supreme Court ruled on the case. They held the Tennessee statute is unconstitutional insofar as it authorizes the use of deadly force against, as in this case, an apparently unarmed, non-dangerous fleeing suspect. Such force may not be used unless necessary to prevent the escape and the officer has probable cause to believe the suspect poses a significant threat of death or serious physical injury to officers or others. So that second phrase is where the officers lost the Garner case, that he was clearly fleeing and not presenting a physical danger to the officer or others at the time the shots were fired. Again, the officer fired quite legally. It was an interesting case at the time. We are so wound up nowadays in race of, was it a black officer or black? Well, it was a black subject, the 17-year-old. It was also a black officer who did the shooting. And it's interesting that as soon as people see the players, the officer at the time had a gigantic afro, which he was allowed to wear on duty. And it clearly is now the other side can call it a black on black shooting. We're so hepped on the races of everybody involved. There were no racial overtones in the Garner shooting. This second case, Graham versus Connor, is also really interesting. The petitioner, Graham, is a diabetic, asked a friend, a fellow named Barry, to drive him to a convenience store to purchase orange juice to counteract the onset of an insulin reaction. Upon entering the store and seeing a number of people ahead of him, Garner hurried out and asked Barry instead to drive him to a friend's house. The respondent, Connor, a city police officer, became suspicious after seeing Graham hastily enter and leave the store, followed Barry's car and made an investigative stop, ordering the pair to wait till he found out what happened. He sees a guy run from a convenience store, jump in a car with another driver, and speed away. Obviously, the officer presumes or thinks there might be a robbery or a grab merchandise and run or something going on. So the stop on its face seems pretty reasonable to me. He ordered the pair out of the car and waited till he got radio information from the store as to what happened. Backup officers arrived at the scene, handcuffed Graham, and ignored or rebuffed attempt to explain and treat Graham's condition. During the encounter, Graham sustained multiple injuries. He was released when Connor learned that nothing had happened at the store. Graham filed suit in district court under 42 U.S.C. 1983 again, alleging they had used excessive force in making the stop, a violation of rights secured under the 14th Amendment to the United States Constitution and 42 U.S.C. 1983. The district court granted the respondent's motion for a directed verdict. That means the judge just says, we're not going to send it to a jury. This is how the case went. It's a matter of law, period. And he directs a verdict at the close, applying a four-factor test for determining whether excessive force gives rise to a 1983 cause of action, which means is the force applied in, it means, was the force applied in good faith to maintain or restore discipline or maliciously and sadistically for the purpose of causing harm. There's a companion case that was heard a few years later, Johnson versus Glick, that generally applies a test to that, this four-prong test, and I'm not going to get into the weeds of all of that. But in this case, although the force was not maliciously applied, anyway, it ended up this. All claims that law enforcement officials have used excessive force, deadly or not, in the course of arrest or investigatory stop or the seizure of a free person are properly analyzed under the Fourth Amendment's objectively reasonableness standard. So the question is, was what the officers did expressly reasonable? The court held that it was not. When the guy explained to the officers about his friend being diabetic and so forth, the officers weren't listening and believed it was just a statement that was untrue to take pressure off of them. And so Graham versus Connor was lost by law enforcement. And they held that citizens have a right to be secure in their person against unreasonable seizures and must be judged by reference of the reasonableness standard under the Fourth Amendment. There's a whole lot more stuff here that in the interest of time I'm going to skip. These cases involve generally litmus tests of previous cases, what to look at, so forth and so on, that we teach in police academies generally about officers making split-second decisions and but what they do still has to be reasonable. While I'm here, we're going to break in just a second. I want to address one other thing. You're hearing a lot of stuff on TV now about case law where it is adjudicated whether the officer was reasonable or not, and they have, these judges said one way in a case, comma, and then it says Judge so-and-so in dissent said da-da-da-da-da. When we teach this in police academies, the reality is this, folks. What the majority of the Supreme Court said is the decision. Everything after that said in dissent, this other judge said that, as much as we may like the dissenting judge or like his opinion, it doesn't matter. It only matters what the court majority said. So don't get hung up on the internet that in dissent, Judge this said that. Judge Kavanaugh said in dissent, da-da-da-da-da-da. If he wasn't in the majority, it has no bearing legally in court. It simply makes news headlines, but it don't matter. Now, we're going to break for a word from some of our friends and associates one more time. This is a reminder to all our listeners. Keystone Corporation, it's a conservative organization that I'm on their board of directors, is having their annual dinner on Tuesday, October 6th, 2020. The featured speaker is Karl Rove. It is at the Venetian Hotel. For information, you can visit online to www.keystonenevada.com. and get all the information. Tables are available for groups, and Karl Rove is an amazing commentator. You don't want to miss this. It is going to be the conservative event of the year. Attorney Donald J. Green, a common guest of mine on Fired Up. He can be reached at 702-409-8239. He specializes in gun case litigation. He is your man. Don Green, 702-409-8239. And Battlefield Vegas, my new kind of home for this show. They're on Circus Drive, directly behind the Circus Hotel and Casino. You can find them there with CCW classes and an amazing place for gun rentals, everything you could possibly imagine. Check out, if you're in town as a tourist, check out battlefieldvegas.com. We're right on time for the length of the show, but I'm going to run this one more story because it's so appropriate in today's times, and I need to get some comments on this incident on the air. The Washington Post, a reporter named Marvin Joseph and others reported August 9, 2020 in southeast Washington, D.C. An early morning shooting left 1 dead and 20 wounded Sunday as hundreds attended a block party in the Gateway neighborhood of southeast Washington. A 17-year-old was killed, and off-duty D.C. police officer suffered life-threatening injuries when a dispute broke out early Sunday at a cookout attended by hundreds of people in southeast Washington. At least 3 shooters opened fire from different locations around 12:30 in the early morning on Dubois Place in the Greenway neighborhood. The unidentified off-duty officer, who apparently was at the party, was critically injured and was fighting for his life as of last report, the D.C. Police Chief Peter Newsham said. Officers say the officer, who is 22 years old and has been on the force for about a year, was struck in the neck. Authorities said there was a dispute over dispute before the shots were fired, and police say they think there was an exchange of gunfire. At least 11 victims were women. Police initially said 21 people had been shot, but later determined that one of the individuals had not been actually struck by a bullet. Videos posted on social media show revelers partying shoulder to shoulder near Dubois Place and 34th Street Southeast. After the shots, some victims fell while others scattered. The crime scene sprawled over blocks with police marking 170 pieces of evidence, mostly shell casings. Police said nearly 100 bullets were fired. I love that. How about shots were fired? But anyway, it's a police report. The party said the tragedy that ensued revived questions about large gatherings that flout Major Muriel Bowser's order that prohibits groups larger than 50 people. Chief Newsham said the police had been aware of the party through an online advertisement for the event and were monitoring it. He said officers called in additional help as the crowd grew. They did not think they had enough officers to break up the gathering. He is reviewing the response from the 6th District. He said it appears officers were present when the shooting occurred. The administration was exploring whether to penalize the promoters of the block party who had advertised the event on Instagram. Authorities Sunday were hard-pressed to recall another time when so many people had been shot in a single incident. More than 115 people have been slain in the district this year, a 17% increase over this time in 2019, which ended a year with a decade high. Those killed were an 11-year-old boy shot in an anti-violence cookout on the 4th of July, and a 71-year-old shot while protecting her granddaughter. Chief Newsham said he blames the availability of illegal firearms and the fact people were caught using them, not deterred by the criminal justice system. The criminals aren't paying attention to the criminal justice system. He also said criminal suspects freed from jail because of the coronavirus pandemic are contributing to the violence. Well, they're also contributing to the spread of the disease, right? If you let them out of jail because they've got the virus, then they're going to be out in public affecting who else? Speaking from the scene of Sunday's shooting, Mayor Bowser indicated any law enforcement may have to become more aggressive, and the community is going to have to understand that some people may have to go to jail. Duh. They're murdering everybody at random, and the only thing, I'm going to get off on a longer rant here. This story was almost completely ignored by our left side media, zero coverage by the major networks, and Chief Newsham assigns blame to the availability of firearms. I don't believe that firearms loaded, aimed, and go off by themselves. He more correctly adds the fact that there is a little deterrence from the criminal justice system. Criminal suspects freed from jail because of the virus are contributing to the violence, and maybe the spread of the Chinese flu also. Our new vice president candidate has expressed the same views already. Taking away firearms and releasing criminals will make America one big happy country. If there was ever an election of consequence, 2020 is it. You gotta get out and vote, folks, or you're going to lose America and going to lose your guns. You can check out my recent shows at firedupwithboberwin.com. It contains several dozen episodes. Please patronize our friends and supporters. We'll be back next Thursday on my website, firedupwithboberwin.com, on the American Guns and Glory Network, numerous other websites, television, and radio stations. When watching any media, just click on subscribe and the new shows will be sent to your phone or computer automatically. My logo merchandise, hats, shirts, and books are available at Battlefield Vegas, just behind Circus Circus on the Las Vegas Strip. If you're ever in Las Vegas, visiting Battlefield Vegas is a must-see attraction. You can shoot a minigun or any of hundreds of firearms and even crush a car with an Abrams tank at their outdoor facility. Transportation, of course, is provided. You can contact info@battlefieldvegas.com. Thank you for watching Fired Up and supporting our many projects. I'll be back next week with another edition. Thank you.